there. Mr. Zivian, how are you, sir?
Walkers. Yes. All right, Mr. Fanego.
Yes.
Both Walkers have retained out, so you're all set.
Cadavian Walker has a retained attorney?
Correct.
Okay. Thanks a lot, Judge. I hope you all have a wonderful Christmas.
You too. Thank you.
All right. Bye-bye.
All right, bye. Okay. Just make sure I got it. Case number 2515. This is off of Judge Gross Docket 251543 FY. People State of Michigan versus the Shantz Jonathan Bush. Mr. Bush is charged with a four-defendant complaint with count 1 armed robbery, count 2 felony firearms, count 3 assault with the intent to murder, count 4 felony firearms. 251544 FY. People State of Michigan versus Cadavian Walker. He's charged in a four-defendant complaint with counts 1, 2, 3, and 4 of counts 1 armed robbery, counts 2 felony firearms, count 3 assault with the intent to murder, count 4 felony firearms. 251545 FY. People State of Michigan versus Quavion Walker. He's charged in a four-defendant complaint with count 1 armed robbery. And 251546 FY. People State of Michigan versus Jawan Malik Williams. He's charged in a four-defendant complaint with count 1 robbery. Appearances for the record.
Your Honor, this is not my case. It's assigned to SP Daniela Brandy.
Yes,
She's on the screen.
Thank you. Good afternoon, Your Honor. Daniela Brandy on behalf of the people in all four cases.
Good afternoon, Judge Patrick Nineheist, P76343.
Hold on 1 second. 1 second. Back up. Comfort breaks, Mr. Ninehouse. Go ahead, sir.
Good.
Speak louder so they can hear you.
Andrew Siddle, P87447, on behalf of both Walkers, Sequavion and Cadavion.
Mr. Ninehouse.
Sorry, Judge. Patrick Nineheist, P76343, on behalf of Mr. Deshantz Bush, who's present via Zoom. We consent to a Zoom hearing.
Fine.
And Judge, my name is Arnold Weiner. I'm representing Jawan Williams.
Bush, state your name.
Deshantz.
State your full name, government name, full name.
Deshantz Bush.
Mr. Zequavion Walker, state your name for the record.
Zequavion.
Cadavion, state your name for the record.
Cadavion Walker.
Mr. Williams, state your name for the record.
Juwan Williams.
Okay, so we're here for a probable cause conference. How are we proceeding?
Your Honor, I did tender discovery to all of the defense attorneys that I was aware of as of yesterday. It was my understanding that the Walkers were represented by Mr. Fanego yesterday. So discovery was tendered to him. I still need to tender discovery to the newly retained attorney. So I'm going to turn it over to the defense counsels how we're going to proceed. I anticipate that we are going to set this for exam. And so ideally it would be best to have the exam held with all four defendants. So I believe I will ask for an adjournment today so that I can tender discovery and then coordinate with the defense attorneys a date that works with everybody to set this matter for exam.
Right, and then FYI, I wasn't going to set an exam date anyway. This is on Judge Gross's docket, so I'm going to let her control that.
Okay.
Mr. Ninehouse, how do you proceed?
Judge, I agree with Ms. LaBrandy. I think that since there's a new attorney, we should adjourn the PCC, but I would like to address bond when appropriate.
Proceed, Mr. Weiner.
Yeah, there's some videos that are not coming through on our screen, but I'll talk with Ms. LaBrandy about that. And I think we should set it for another PCC first, Judge. I agree with that. Thank you.
Yes, sir.
and we'll waive the 21-day rule if necessary.
Yes, Your Honor. I will agree to stipulate to the adjournment of the PCC. I also have a bond issue that I would like to raise.
Okay, so the court will find this cause and all court matters to wait for 21 days. You're not waiting for an exam. You're gonna have an exam, gentlemen, but it's gonna be set out probably at a later date so where you all can get discovery and figure out how you want to go forward, okay? So that's the bond. Who wants to make the first?
Well,
Judge, I'll go first if you'd like. For Mr. DeShance Bush, right now his bond has no bond or bond denied, and I think that's I think that's just wrong because I don't know what the reason would be for having no bond. He's not charged with treason or murder. Granted, it is a life offense, but it's not one of those ones that's prohibited from having bond. So Mr. Bush is currently 18 years old, lives with his mother and his sister, or two sisters, sorry. He's currently living in Auburn Hills, but he lived in Pontiac for the last 2 years and Oakland County for the rest of his life besides that. He successfully graduated high school last summer, or beginning of last summer. He has a strong family support. His mom's been calling me and getting a hold of me many times. His mom actually wanted to come to court today and was either going to show up or was going to appear on Zoom, but I think she actually showed up today. And I know that he has never had a failure to appear before. He does have no prior criminal history, but in full understanding, he has a January 8th, 2026 preliminary examination for a carrying concealed weapon charge, which is, after I read through some discovery, it seems to be related to Ms. LeBrandy's case, this current one we're on. And I know that he hasn't failed to appear that, but that CCW case happened in time after this alleged incident. So it was this would be his first ever contact with the law, except he got pulled over with a CCW charge. So I'm asking for a $50,000 10% bond. He turns 19 on the 25th. Otherwise, he has no prior criminal history, like I said, and I'm just asking for him to actually get a bond. Thank you.
We'll just do it one by one. Ms. LeBrandy.
So, Your Honor, I will note that in this case, this is the allegations involve that these four individuals arranged for to buy drugs from an individual and then basically held him up at gunpoint. Three of the four individuals in this case were in possession of firearms. Mr. Bush was in possession of a firearm. There was actually a single shot that was fired, and it appears from the CCTV video that Mr. Bush was the one that actually fired his firearm on the night of the evening. And the CCW that defense counsel refers to is a case in which the defendant was pulled over in vehicle. He was found with a firearm, and that firearm, the ballistics match the shell casing that was recovered from the scene in this incident. And so, given that this is a capital case, the allegations are quite serious. I will also note that these four individuals, it is believed that they are gang associated. In this case, they do associate themselves with a smaller subsect of a Bloods gang group. While there may not be any criminal history for Mr. Bush, I do not believe that this is the first time that he is engaged in some of this behavior. And so for those reasons, I do not believe that there was any abuse of discretion in setting the bond. But I would ask that if Your Honor were to amend the bond and Mr. Bush is able to post that bond, that a GPS tether be ordered.
Judge, if I can if I can just respond. So I know Ms. LeBrandy said there was only one gunshot, but apparently Officer Mounts or Deputy Mounts was alerted by Flock Raven gunshot detection system of multiple gunshots. So there was more than one gunshot there. Just because they found one shell casing doesn't mean that there was not more gunshots than that. Plus, it appears that this could be a potential case where there's a good defense based on self-defense in this matter. And again, I got discovery yesterday. Thank you, Ms. Brandy. But I haven't had to go through this. I have no idea about this gang. I guess we can just allege whatever. I don't have any proof of any gang ties or any proof of, him getting in trouble beforehand. I know he successfully graduated high school, so I don't know why she could say she believes he did something in the past. that he hasn't been caught for.
Mhm.
You guys box that out in front of Judge Gross. So the statute, if we're going to cite the statute, we got to cite the entire statute, not just the parts that's favorable to us. The court may deny pretrial release to a defendant charged with murder or treason or committing a violent felony, and at the time of the commission of the felony, defendant was on probation, parole, or release pending trial for another violent felony. I don't think CCW counts as a violent felony. Or during the previous 15 years, the commission of a violent felony, defendant has been convicted of 2 or more violent felonies under laws of the state or substantially similar laws of the United States or another state arising out of separate incidents if the court finds that proof of the defendant's guilt is evident or presumption is great. She did not abuse her discretion in denying bond per the law, and then also it says the court may deny pretrial release to a defendant charged with criminal sexual conduct in the first degree, robbery, or kidnapping with the intent to extort money or other valuable things thereby. If the court finds that the proof of the defendant's guilt is evident or the presumption great, unless the court finds by clear and convincing evidence that the defendant is not likely to flee or present a danger to any other person. So, the magistrate was well in her power under the Michigan court rules to deny his bond. So I just want to correct the record on that.
Thank you, Judge. Sorry, I was just going off memory.
So, in this case are pretty steep as far as the gun being involved. It was just a lot going on. It sounds like a drug deal, which is not legal, and then guns brought in, the people robbed. But we'll set the bond in this matter at $250,000 cash only. Then a GPS tether on home confinement if he posted. So still banned.
Mhm.
Thank you, Judge.
Mr. Bush is all set. We didn't get a date yet. So
Yeah, Judge,
what date are we going to do the probable cause conference, everyone? I can give 30 days, so we can come back the 27th, or I can give you guys 30 days and put you back on Judge Gross docket on the 27th or the 29th of January.
Hold on, 27th or the, can
Either
we
day
do it,
works with me, Judge.
Judge, can we do it in the afternoon? Is that possible? On Tuesday, the 27th?
All PCCs at the 50th District Court in Pontiac are at 1:30 on Tuesday and Thursday afternoons. Which day do you want?
Tuesday, the 27th?
Does that work for you, Mr. Ninehouse?
Yes, Judge, that should work for me.
Does that work for you, sir?
Yes, Chairman.
All right, 127, 26, 1:30 p.m. on Zoom for everyone.
Is that,
So
oh,
this-
that's Zoom, right, okay.
That's Zoom, yes.
That's Judge Gross, correct?
Correct.
Okay, I'm sorry, may I chime in and do my quick motion for bond for Mr. Williams? Or I'll wait till after?
It's for you guys, so I'm trying to take it all in order and make sure nothing gets
Okay.
messed up. So,
Thank
Mr. Bush, you're all set. Right, so that's Mr. Bush. Yeah. Are you gonna make an argument for him or no?
Yes, sir.
All right, go ahead.
Similarly, Your Honor, I just met with the defendants' families this morning, and they retained me, and I just filed my appearance this morning in both matters. And I spoke to them, and they have told me that they had never the defense have never spoken to their court-appointed attorneys ever before, and so we're no longer continuing them. So my most urgent issue was the bonds, and I would agree to the exact same conditions with the tender. The only additional request I would make would be at a 10% bond because they've expressed some financial difficulties. They are both employed. One's in a nursing home, and the other's a home health provider. And I can agree to tethers, and if we could get them bonded out. I just filed a defense request for discovery today, but I will coordinate with the prosecution to gather all the information, and then we will be here for the next hearing.
Go ahead.
Also, the court clerk and the Oakland County's prosecutor's office gave me Mr. Robert Zivian's information to contact him. I had contacted him this morning. He responded that this is not his case.
It's not. It's in front of Judge Gross. So no. This is LeBrandy's, APA LeBrandy's. This is a specially signed case. So
Yes, sir.
yes. All right. So we'll say his bond at $250,000 cash only. GPS tether home confinement. So I will see him on January 20th. Well, Judge Gross, I'm sorry, to see him January 27th, 1:30 on Zoom. So that's Mr. Quavion. Okay, as to Mr. Kadavion.
Yes, Your Honor. The defendant is a young man, and there was no other history of similar first time offense for these types of offenses. And so we would just make the same request that we have a bond in place. And I would also request a 10% bond with the same conditions as agreed upon. So that we can get them home, and they will be complying and appearing for all court hearings and court dates.
$250,000 cash, GPS tether home confinement. They'll be in front of Judge Gross on the 27th of January, 1:30 p.m. for probable cause conflicts. Mr. Williams, this is yours, Mr. Weiner, correct?
Yes, Joanne Williams. Judge, my understanding, Mr. Williams is 19 years old. He has his GED. I don't see a prior record, but he indicates he's on a HIDA for a case, to be candid with the court, and I understand he was the one of the four people that did not have a gun, did not fire any shots, and I think the theory on him is that he simply aided and abetted that he was the one to set it up. But other than that, our position, he was simply present there. No gun, no firing shots, no interaction with the victim. So I would ask for a $50,000 cash surety, 10% bond. His parents resided in Pontiac. They now reside in Waterford. He's never failed to appear for any court appearance, and I will make sure of that. Thank you.
Go back to be fair. So I didn't see a weapons charge of Mr. Zaquavion. That will change my thought on bond. Was there allegations of him with a weapon, Ms. LeBrand?
No, it's believed that he was the only one that did not carry a weapon. However, Your Honor, I will note that there's video that shows that he perhaps was the individual who was on the phone with the victim and communicating with the victim and setting things up. I'll also note that these four individuals, they were together the entire time. They often exchanged a backpack between one another. I don't think that it's because Mr. Williams did not want to carry a firearm. I just think it's because there were three guns that evening, and there were three people that decided to hold them. But they were exchanging of property. At one point, it appeared that everything was in that backpack, and so they were just passing them out at the time. It seemed to be a communal bag in some respects. So I just think that it was by circumstance that he was not one of the individuals holding the gun at the time.
In his bond, so $150,000 cash.
Can you give us a 10%?
No. And then Mr. Williams will do $150,000 cash GPS tether. And we'll see him, Judge Russell, see him on the 27th.
Thank you, Judge.
Can you make that cash? Can you make that cash or surety, Judge?
Sir.
Please.
No, sir. You can talk to Judge Gross about it, and then if the exam goes and she feels after the exam it can be modified. I took it from a denial, so.
Okay. Thank you, Judge. We'll log off.
Thank you, Judge.
All right, thank you.
Thank you all.
Thank you.
Thank you.
Did you adjust?
Are we all set with Cadavia and Walker?
All of them are all set. Thank you.
Okay, thank you.
Is it quite now?
It did, yeah. Okay.
Thank
Do I leave?
Yeah.